Afternoon, everyone. Welcome to the third session of the two-day national webinar on constitutional morality in India, past, present, and future, organized by the Department of Political Science, University of Kerala. The theme of the session is constitutional morality, social change, and social morality. So we have an eminent speaker for this session, Dr. G. Mohan Gopal, former director, National Judicial Academy, and he was the director of National Judicial Academy of the Supreme Court of India from 2006 to 11, and from 2012 to 19 he was the founder chair of the National Court Management Systems Committee of the Supreme Court of India, and he was also the former director of the National Law School of India, Bengaluru, and he continues to work actively on current judicial and legal issues and reforms of legal and judicial institutions. And currently, he coordinates an informal platform on law and justice called the Center for Legal Change. And now I invite the chair of the session, Dr. Joseph Anthony, Director, Center for Marxian Studies, University of Kerala. Over to you, sir.
Thank you, Niruvama. Respected distinguished Professor Mohan Gopal, faculty members of political science, the coordinator of the program, Dr. Arun, dear students. I'm extremely thankful and happy to Dr. Arun for giving me an opportunity to chair an important session in which a very eminent personality is the key speaker. I'm rather proud that a Malayali like him has been in the field of legal education at the apex level, in the sense that at the Supreme Court level or at the national level, he has been very active. And if you look at the educational background of Professor Mohan Gopal, we will be very proud of, because he got his degrees from the most important and prestigious university in the world. And that itself shows his positions he is holding now and held before. And I hope that he is an apt person, very apt person to speak on any legal matter, constitutional matters. If you look at the Constituent Assembly debates and the process in the making of the Constitution, we can see the debates and the visions of our constitutional fathers. And it is, our Constitution is not a mere document created by some motley group of people sitting together and created a particular constitution. In fact, from the end of the 19th century, our constitutional fathers were or freedom movement leaders were in fact thinking about a constitution of our own. And they had their own vision, because from the constituent freedom movement, they have got a lot of ideas, and they are not, these leaders were not persons who were aloof from the people. They were among the people, and they know the pulse of the people and to know what is the real India, from Gandhiji onwards, all other persons, even before them. And such was the Constitution. And if we look at Constitution, we can look at Constitution from different perspective. And I consider, from the experiences of freedom movement leaders and on the basis of their vision, and on the basis of the reality, what is India, they considered our Constitution as an important catalyst for social change. And we can see that kind of a perception, a Constitution as a tool, a revolutionary tool for social change. You can see from the very preamble to the schedules. And we know that how far our society was, it was a layered society, a kind of prismatic society. This was mentioned by Riggs. And in a particular society like us, see, they were very sincere and very particular about they have to achieve some kind of social objectives. And they have done a lot of work for that and created such a constitution. And we know from the very word, we the people, to the different provisions included in the schedules also, show their commitment to achieve that kind of a social revolution in society. See, Granville Aston, persons like Granville Aston in India, Rajiv Bhargava, etc., thought about how constitutional fathers visualized a constitution for social change or social revolution. But see, when we are preparing to celebrate the 75th anniversary of independence, and when we are completing more than 7 decades of our constitution, what is the constitutional morality? Where is our constitution? Where are our constitutional values? Where are our basic principles of our constitution? And what is the social morality? See, in an article written by Gopal Guru, stated that there are 2 different universes. That one is state universe and another one is civil society universe. And this civil society universe is the center, is the universe which is holding the morality, constitutional, social morality, or say constitutional morality's energy. And unfortunately, we don't see that kind of a morality, social morality. It's a kind of enabling thing. See, you know that the constitution is a document. If it is not properly worked, and in fact, we need a kind of an environment, enabling environment for the smooth working of the constitution. And we know that, even just before the passage of the constitution on 26th November 1949, on 25th November, I think, Ambedkar made a statement emphasizing the contradictions in society, and he stated that we are entering into an era of contradictions. That was the reality. There were certain contradictions, and the constitution was a kind of tool to remove all kinds of contradictions in society. And the most important element for solving all these contradictions along with the constitutional principles is social morality or constitutional morality. And see, I am not going into the problems of social morality, constitutional morality, and constitutional principles, because we have got a very eminent personality to delve deep into the topic. But in a particular situation where India is finding it very difficult to move on because our democracy is in a particular situation, on the basis of that, our constitutional values, our courts, our legislature, etc. Almost all important constitutional institutions are under stress. And why? Why this situation? How this situation developed? And what is the way out? How constitutional or social morality can strengthen constitutional morality? How we can achieve? See, how we can regenerate our constitutional values? These are the questions. See, the entire seminar is going to discuss, and I have listened to the speech made by Neera Chandok in the last session, and all these persons were seriously thinking about the predicament we have achieved now. And I'm very happy that we have a very eminent personality like Professor G. Mohan Gopal is here to deliver an important speech on this particular topic: constitutional morality, social change, and social morality. And I very proudly and happily invite Professor Mohan Gopal to deliver his speech.
Thank you very much, sir, Professor Joseph Anthony, for your kind words and your very insightful comments, which I think have set a very fine beginning to our discussion. It's an honor and a privilege for me to be in the presence of Professor Joseph Anthony, and a very distinguished academician, and many others. And I'd like to thank Professor Arun for giving me this opportunity. I think he's done a great job in organizing this very interesting and I think very timely set of reflections on the issue of constitutional morality. I will speak for a bit, and then perhaps we can have a discussion. I will look at constitutional morality naturally from a legal point of view. In my work, I very much think that each discipline needs to have its own understanding of many fundamental issues. So I don't believe that I should necessarily borrow from a political science understanding or a social science understanding of what is morality. Not that, of course, we are all open to and we learn from, and we don't exclude any understanding from any discipline. But it is important to understand each concept also from the perspective of our own discipline. Otherwise, we will not have clarity in applying it into our own context. Why do I say this? Because I consider law as a discipline that is involved with the challenge of constraints on human conduct, which are imposed with the approval, not necessarily by, but with the recognition or approval, or directly by a source that claims sovereignty. And sovereignty is a separate political and legal concept. But that's what sets it apart from morality, which also sets constraints on human conduct. But morality need not necessarily come from a source which asserts sovereignty. Sovereignty, as I said, is a very complex concept, but need not even claim sovereignty. But for law, we need to, it is a system concerned with, or a discipline concerned with the issue of constraints sought to be set or actually set on human conduct. From a theoretical point of view. And as I said, for it to come into the realm of law, there must be some claim of either emanating from a sovereign authority or being recognized directly or indirectly by some, if you will, backstop of sovereignty. And that's what sort of makes it law. And when I say law, I include also formal and informal customary law. Article 13 of the Constitution recognizes various sources of law and provides that these other sources shall not have the force of law in India if they are in conflict with our fundamental rights. I'm also not going to get into the legal famous Art Fuller debate on the relationship between law and morality. That's a very exciting topic, but that's will take us far away from our topic of the day. And as we know, Fuller argues that all law is based on an internal has an internal morality, and so we cannot separate law and morality. And Fuller argues the opposite. But I'm not getting into that either. Instead, within the limited time available to us, I am going to start from the assumption that Dr. B.R. Ambedkar very explicitly and very consciously in his speech in 1948, in which he introduced the draft constitution to the Constituent Assembly, asserted a doctrine of constitutional morality in constitutional law, because he was speaking in the Constituent Assembly as a jurist and as the chairman of the drafting committee. So he made an assertion about constitutional morality. And so our starting point is, I'm just discussing today that concept of constitutional morality that Dr. Ambedkar referred to and inserted into our constitutional law through the Constituent Assembly debate. I'm saying inserted into the constitutional law of India, not simply because he included it in his speech in the Constituent Assembly debates, but because in several judgments, including a 2018 judgment, the Government of National Capital of Territory versus Union of India, the Supreme Court has taken judicial notice of the speech of Dr. Ambedkar and has also expounded on constitutional morality. So Dr. Ambedkar's intervention in the Constituent Assembly on constitutional morality has acquired legal recognition and is therefore part of our constitutional law, because the Supreme Court of India on a number of occasions has recognized the concept of constitutional morality, explicitly referred to Dr. Ambedkar's speech in which he introduced this idea into Indian constitutional law, and has also further expounded on it. So we do have in our Indian constitutional law a very clear and concrete and specific idea of constitutional morality, which we should not confuse with the larger issue of law and morality, Lon Fuller and Hart, and or philosophical or social or political ideas of morality. Of course, they're relevant, but this has now acquired an independent legal constitutional law existence, independent of those debates. So that's what I wish to look at. And I'm also, I will explain the constitutional morality. And I will argue that if you look at the intervention of Dr. Ambedkar in 1948, a dozen years after he published his undelivered speech on the annihilation of caste, a couple of decades after very extensive work on fundamental social change in the country, I do argue, and I will argue today also, that Dr. Ambedkar introduced constitutional morality as a weapon against traditional Brahminic morality in order to counter it, because he recognized that democracy, which is at the heart and soul of our constitution, is, as he said in his own words, is a thin topsoil. We have only a thin topsoil of democracy in the country, which is deeply embedded in a traditional morality. And therefore, he introduced constitutional morality as a legal instrument against Brahminic morality to bring about social change. And so I will explain this background a little more. And then I will briefly look at the operationalization of this of the idea of constitutional morality, and on the other hand, its face-off with traditional Brahminic morality. In a particular case of great importance to us in Kerala, the Padmanabha Swami temple judgment we have two judgments, the Kerala High Court judgment and the Supreme Court judgment. And in these judgments, we can actually see a face-off between constitutional morality and Brahminic morality. So I will conclude by demonstrating how this confrontation between constitutional morality and traditional Brahminic morality is playing out in constitutional law in the context of a particular very interesting and very important judgment. So this is what I'm planning to do. So let me, it's now 2:20. So let me just very briefly set out the approach of Dr. Ambedkar and the Supreme Court to what they call constitutional morality. Dr. Ambedkar, in his speech, he, as we all know, very famous speech. Everyone knows this. Everyone has read it. I'm very sorry I could not listen to the morning session because I was actually handling a session with a Judicial Academy in the first half, entire first half. So I requested Professor Arun if I could quickly see a recording of that first session, but he explained to me that that would not be possible, that's still being edited. So I don't have the benefit of that earlier session. But I would not be surprised if in the earlier session there was a reference to Dr. Ambedkar's speech in 1948 on constitutional morality, which he was the one who brought this concept to our constitutional law. And also his quotation of the British historian of Greece, Grote. Now, if you distill from that, you will find there are five elements to Dr. Ambedkar's definition of constitutional morality. The first is, of course, the word morality we use in the general sense of the word, without getting into, as I said, the other debates, as a set of moral qualities, as a system of our doctrine of ethical duties. That's the sense in which I think Dr. Ambedkar also uses it. And that's evident from the content of it. So the five elements that Dr. Ambedkar, through his quotation and through the quotation from Grote and through his own intervention, that he identified as the constituent elements of constitutional morality are: number one, paramount reverence for the Constitution. So that's a quality, a mental attitude. Very, very strong words taken from Grote. Paramount reverence for the Constitution. So you can also see implicit already in it a contest between other moralities and constitutional moralities. When you say paramount, it means that there is a contest going on there. There are competing moralities, and you want reverence for the Constitution to be paramount because it is competing with reverence to other systems of thought. Second, he says that a constitutional morality is a morality that demands obedience to authority, acting under and within constitutional forms. So you could say that it is a kind of rule of law concept that, but again, there's not much time, but it's a very profound idea, more from what it excludes than what it includes. So it is a constitutional morality that says that we will obey only authority acting under and within constitutional forms recognized within the Constitution, which means that we will reject traditional and other forms. Now, as I said, Article 13 of the Constitution recognizes other sources, but that has been brought into the constitutional form, subject to, of course, as set out in Article 13, that they shall not be in violation of the fundamental rights under Part 3 of the Constitution. So, therefore, taking Article 3 definition into account, it's very clear that constitutional morality demands a rejection of any authority that is not acting under and within the constitutional form of government. So we should not recognize it. We should not even discuss it. Anything that we discuss must be within and under the constitutional form of government. Third, the constitutional morality must guarantee, must provide for, should not impede three things. Number one, open speech. Open speech, not just freedom of speech of the individual, but open speech. Second, all action must be subject to legal control and to legal accountability. So nothing is above the law. Again, a rule of law concept, that all actions must be subject to legal control and accountability. So we are familiar with many religious assertions that faith, for example, cannot be subject to legal control or legal accountability. So we can see that there is a real clash there between the approach to religion as being above the law and authority that exists within and is created by the forms by constitutional forms. So they're not from any other source. Third, there must be unrestrained censure of public authorities. Unrestrained censure of public authorities. So the freedom to question. Now again, strongly opposed to the demand for blind faith and obedience in religion and religious authorities. So we can see this contest being set up by the definition of constitutional morality as really excluding the sources and content and demands made by traditional authorities. So this is a third element, which had these three sub-elements. And the fourth element is that the form of administration of the Constitution must be consistent with the form of the Constitution and the spirit of the Constitution. That's a part of the ethical system, the system of right conduct, or what is seen as right conduct in a constitutional democracy. Must include, as I said, fourthly, that the form of administration, those who administer the Constitution, executive, judiciary, legislature, those who administer the Constitution must do so consistent with the spirit of the Constitution and the form of the Constitution. There should not be a clash between the form of the Constitution and the form of its administration. In fact, Dr. Ambedkar says that in the speech that it is very easy, and we are seeing this happening, for a constitution to be perverted. He uses the word perverted, again in quotation, perverted by by changing not the form of the constitution, but by the form of its administration, which is really what we are seeing around us today, not just in the last 5, 6, 7 years, but maybe in the last 20 or 30 years. Accelerated, intensified in the last 6 or 7 years. Then lastly, Dr. Ambedkar would, and through his intervention, would identify the acceptance of this is a Grote quotation, not an Ambedkar quotation, but he endorses it, and we must take it in its secular sense, not in its religious sense, a shared acceptance of the sacredness of the Constitution. And so this quotation tries to shift sacredness away from religion and to the Constitution, and therefore a shared acceptance of the sacredness of the Constitution. And they also demand, of course, that there must be a diffusion of constitutional morality, not simply as a topsoil, but a diffusion of constitutional morality with these five elements throughout the polity, throughout society, at every level of the state and of society, in order for the Constitution to be secure and protected. This is the framework that Dr. Ambedkar set up, and this is the specific understanding and meaning of constitutional morality in constitutional law that emerges from the Constituent Assembly debates. Now, over the years, most recently, as I said, in July 2018, the Supreme Court of India, for example, the National Capital Territory, the government of the National Capital Territory of Delhi versus Union of India, they set out, the Supreme Court sets out in a very interesting set of judgments, including by Justice Deepak Mishra and Justice D.Y. Chandrachud, a further set of 5 elements of the Supreme Court. I'm not, for lack of time, differentiating it between the different judges, but 5 elements set out by the Supreme Court as constituent elements of constitutional morality, in addition to endorsing and giving legal status, constitutional law status, to the 5 elements set out by Dr. Ambedkar. These 5 elements are: number 1, there must be strict and complete adherence to constitutional principles by every member of the of society, from citizen to the highest officials, says the Supreme Court in a 5-judge bench decision. Strict and complete adherence to constitutional principles by every member of the society, from citizen to the highest official. Number 1. Number 2, the spirit of constitutionalism. Every action must be governed by strict conformity with the basic tenets of the Constitution. Number 3, allegiance to the substantive provisions and principles of the Constitution. Allegiance to the substantive provisions and principles of the Constitution. Number 4, a constitutional culture which includes all these elements. So that culture meaning learned habit, that we habitually practice these attitudes. Morality is about attitudes and beliefs and so on. So there must be a constitutional culture. And fifth, understanding of the very, very important, that brings me to the social change aspect. The Supreme Court judgment in 2018 explicitly discusses the description by the Supreme Court in 1980 in S.P. Gupta versus Union of India and in other judgments of the Constitution as a charter for social revolution. And then says that the fifth element is that all of us must have an understanding of the revolutionary character of the Constitution, right? And we must be, our actions must be dedicated to the realization of the social revolution, says the Supreme Court, which is and of the social transformation sought by the Constitution. And we must ensure accountability of the rulers to bringing about the social revolution and social transformation. So there is an explicit link between constitutional morality and social revolution. And in the context of this contest between constitutional moralities and competing moralities. The Supreme Court judgment also makes a very explicit requirement that constitutional interpretation must flow from constitutional morality. That takes me to the actual case that I will very briefly discuss, and also calls for, again, repeats Dr. Ambedkar's call for the diffusion of constitutional morality. So we have a framework within constitutional law of certain principles that make demands of all the officials of the country and all the citizens of the country as part of their citizenship responsibilities to have a certain attitude to the Constitution, a certain understanding of the Constitution, and a certain commitment to bring about the kind of transformation to an egalitarian society based on freedom, equality, dignity, fraternity, and based on specific ideologies such as socialism, secularism, democracy, republicanism, which are very clearly stipulated in the Constitution. So it's transformed constitutional morality from a description of a non-formal, as would be argued by Hart, an extra legal, outside the legal system set of ethical principles which are distinct from the law. The Indian constitutional jurisprudence sets up something which they call constitutional morality, but that does not really fit into conventional ideas of morality. It brings it very much within the framework of constitutional law, but makes demands on the definition of right conduct on the part of officials and of citizens in order to take forward the objectives of the Constitution. So this is the framework of constitutional morality in Indian constitutional law, in very brief summary. In contrast is Brahminic morality. Now there is no, there's no time to go deeply into it, but we would broadly, I think there would hopefully not be too much disagreement if I define Brahminic morality as a set of principles of moral principles, of ethical principles, where the content of morality is derived from the scriptures, from the Brahminical scriptures, and from Brahminical ordinances, divine scriptures, divine ordinances, scriptures and ordinances that Brahminists will consider divine, and which are incorporated into legal codes, shastras, given by accepted lawgivers who have, the special status, birth that has been conferred on them or acquired by them, and are entrenched in customary law that has been practiced for centuries. So we could say that Brahminic morality and constitutional morality really differs in terms of the source of the content of these model ideas and the kind of obligations that it creates. So broadly speaking, constitutional morality source is a constitution and law, a democratically enacted law, and a democratic constitution, which according to Dr. Ambedkar in the Constituent Assembly, and that was widely agreed before the Keshwanath Bharati, was not subject to any basic structure constraint and could be revised and reformed and amended in any way by future generations of elected parliament and state legislatures. So you had that in other words, as was said in the Constituent Assembly's objectives resolution, all power and authority in independent India shall be derived from the people. And so the source of constitutional morality is ultimately the people acting through constitutional forms. In contrast, the source of Brahminic morality is not subject to democratic questioning, review, or control by people. It is derived from God through the priesthood. So ultimately, as far as we know, it is basically sourced from the priesthood that has the last word in it. So it is in this context that in this context of this tussle that the context that I think constitutional morality emerged and should be seen as perhaps as important an instrument of constitutional law as we see fundamental rights or directive principles of state policy, rather than merely a body of morality. Now let me move to the second part, the last part of my remarks, which is to really look at the two judgments the two judgments. One judgment, as I said, is a 2011 judgment of the Kerala High Court, delivered by Justice C.N. Ramachandran Nair, a really exceptionally brilliant judge. I think highly respected, a giant in the field of law and justice. Written extraordinary judgments. This is one of them. And Justice C.N.R. Nair wrote this Padmanabha Temple judgment in the Kerala High Court, as I said. And in the Supreme Court in July 2020, almost 9 years later, that was 2011, almost 9 years later, or about 9 years later, the Supreme Court judgment was written by another giant in the legal system, an excellent, wonderful judge, a real jurist called Justice U.U. Lalit, who is going to be the next Chief Justice of India. And of course, sitting with him was in this two-judge bench was Justice Indu Malhotra. And sitting with Justice C.N.R. Nair in the two-judge bench of the Kerala High Court was Justice Surendra Mohan, another very eminent judge. So we have these two judgments all looking at the issue or the dispute about whether the present-day descendants of the last Maharaja of Travancore, I sometimes refer to that as the last autocrat of Travancore. Maharaja is a title, it doesn't describe the form of government, which is important. For the purposes of our discussion, I don't mean any disrespect to anyone, but for the purposes of our discussion, we need to understand that that was an autocracy, and what we had later, what we have now, is a democracy. And therefore, the question was whether the family, the descendants, the current descendants of the last autocrat of Kerala, inherit the right to control, not own, they did not claim that, but control the administration and the resources of the Padmanabha temple. And this was the question. And elaborate discussion by both judgments. And Justice Ramachandran Nair, C.N. Ramachandran Nair, took what is patently a position that is based on the principle, consciously or subconsciously, on the principle or doctrine of constitutional morality. Because if you look at his judgment, you can see all of these elements are fully satisfied, which I listed out before, and we'll probably come back to that after very briefly looking at his judgments. On the other hand, so what did he do? So what did he do? He basically, in his judgment, he basically looks at the fact that Padmanabha temple was under the control of Ettara Yogam, as we know in Kerala, which is there were 7 potis, 1 Nair representative of the Ettuvittal Pillamar, and half a share of control to the then Maharaja, Martanda Varma. And then conflict developed, partly because of, you all know better than me, because of the European theatre that had moved here, conflict between the Dutch and the French on one hand and the British on the other hand. Martanda Varma took the side of the British. And his rivals in the temple, over the temple, took the side of the other Europeans. That conflict became very violent, and finally the rivals of Martanda Varma, as we know, were defeated. They were murdered. Their houses were razed to the ground. Their women and children were enslaved and given to others. They were just wiped out. They were just wiped out in the most, and they were murdered. The Ettuvittal Pillamar themselves. So there's a violent taking of this very ancient temple in the 18th century. And there was a rebuilding and so on and so forth. But since that 18th century, Martanda Varma controlled it with the temple, and he had a tradition of making of controlling the temple and converted it into a kind of family relationship with the temple, admittedly, and made his intermixed his resources and the resources of the temple in a way that was not accounted for, accumulated huge resources and wealth and treasure in the basements of the temple. And so this carried on during the lifetime of the last autocrat, Balarama Varma, but then after, and this was recognized, the fact that the last autocrat could continue to have the control of the administration of the temple, although it had become a public, during the Maharaja's rule itself, it had the administration of all the temples under pressure from the British had been taken over by the Travancore government to maximize revenue when Travancore was facing a revenue crunch. So including Padmanabha temple, all these temples had become governments under government control to some extent or the other, except that the Padmanabha temple had a very special arrangement of being administered directly by the autocrat and his family. So that continued. I'm just sort of summarizing all this very quickly. That continued during the merger with Travancore Cochin, and later the assumption of office of the last autocrat as a Raj Pramukh after the independence of India. And that was and during this transfer, certain agreements were entered into by India and the last autocrat. And in these agreements, they had recognized that the last ruler would have control over the administration of the temple. Now, the question was, did the reference to last ruler include the family, include his successors, or not? Or was it just literally the last ruler, and that would end with the last ruler? Because there was only one last ruler no one else could have been a last ruler. So the ruler had to be, no one else was a ruler either. There was only one. I mean, the last ruler was the last ruler. There was no ruler after that. So the question was, would the successors who were non-rulers claim to be rulers for the purposes of controlling the temple? Now, this till the last ruler was in charge, there was not much controversy. But after the death of the last ruler, his younger brother Martandavarma, they succeeded him. And there started to be concern amongst devotees about the nature of the relationship between the temple and the family, because in some interview in which he claims the family claims he was misquoted, he was understood as saying that that the temple and its wealth belongs to the family, although it had always been a public temple. And so people were concerned, and a lawyer brought a suit in local courts in Trivandrum. Another lawyer brought a suit, and the suit ended up decreed in favor of the devotees. The local judge, he ordered that, and these those who filed the suit argued that they had no evidence at that time that there were walls inside the temple and in the basement, and there was massive treasure there. This was all denied at that time by the temple management, never admitted. Finally, after this case was filed, Martandavarma admitted that, yeah, perhaps there is one vault with some treasures in it, nothing, no big deal. But ultimately, we know that there were, the number of vaults and huge amount of incalculable wealth and treasure that's still not known, to what its value is. So then the Martandavarma, when the local court ordered that the vault should not be opened without the presence of independent people and so on, and that ordered the government to take control and protect these treasures, then Martandavarma went to the Kerala High Court and sought to quash these orders of the civil court in Trivandrum, and this travelled to the High Court, the litigation. And finally, the High Court judgment was delivered in 2011. The first case was filed, I believe, in 2007. So by 4 years, within 4 years, it came to a head in the Kerala High Court, and it was Ramchandran Nair who delivered the judgment. Now, C.N. Ramchandran Nair in the judgment basically, repeatedly made a distinction between the situation before the Constitution and the situation after the Constitution. He kept on many references in his judgment after the Constitution, after the new law, and after the constitutional amendment abolishing privy purses. He took into account all these changes when the definition of ruler was amended. And he said, I have to go by the constitutional and statutory definition of ruler. The constitutional and statutory definition of ruler does not recognize the successors to the ruler as being the ruler, and therefore the family is not entitled to control it. And in the absence of the family controlling it, the current ruler of Kerala is the government of Kerala under the constitution. Remember Ambedkar saying that constitutional morality demands obedience to authority acting under and within constitutional forms. Within constitutional forms. So Ramchandran Nair was very clear. Within the constitutional forms, there is only authority for the government, and he said this belongs to the government, and the government must act to protect it. Yet it was very clear. The law is very clear. I'm not getting into the detailed legal discussion here because I've actually organized a separate webinar on this judgment some months ago in some detail, and so I'm happy to do that again or go through that. But he makes it very clear. So he shows paramount reverence for the Constitution. He says that the situation changed when the Constitution came into effect, whatever had happened before that. Now we go by the Constitution. He shows that he shows obedience to authority acting under and within the Constitution. He administers, he interprets the law, and which is a form of administration of the Constitution recognizing the spirit of the Constitution and the values of the Constitution. He talks at length about the need to protect the public, the devotee public, and to ensure that their interests must be protected. He says it's a public temple, it's not a private temple. Government gives money to the temple, public money is spent, and therefore there is public accountability. Remember that the doctrine of constitutional morality emphasized explicitly that all government action must be subject not only to to censure of public authorities, but also to legal control and accountability to the public of the actions of the authority. So Ramchandra Nair's judgment explicitly operationalizes these principles, and he talks about the public interest and the interest of the devotees that have to be protected. He talks about the archaeological importance of the temple, of this ancient temple, as a heritage that belongs to the public, and the government having to protect it. So applying these very specifically, the principles of consciously or unconsciously, he does not refer to constitutional morality. Indeed, this judgment of 2011 was 7 years ahead of the 2018 Supreme Court judgment, which laid all this out in some detail. He also understands in a very sensitive way, Justice C.N. Ramchandra Nair understands the revolutionary character of the Constitution, which was one of the criteria set out by the Supreme Court very clearly, that you must realize the social transformation that the Constitution envisages, that we will be ruled by democracy, where we cannot recognize autocratic rights. The rights of autocrats have no recognition in a democracy, no legitimacy in a democracy. And to blur the distinction between the public and the private roles of autocrats at a time when there was no such distinction. Because that distinction came from democratic ideas. Those days, what the king did was what the king did. There was no question of public or private. So therefore, to reject the legitimacy and legality of arrangements entered into by autocrats in an autocracy, not in a democracy, except to the extent explicitly recognized and accepted by the law under the Constitution, recognized under the Constitution, which CNR Nair does in terms of recognizing the rights of the last autocrat, that was recognized as part of the peaceful transfer of power to independent India. A covenant was entered into. Those covenants had certain provisions. He interpreted and respected that, but he said, look, but we have to understand that today the only ruler is the government of Kerala, and the government of Kerala is therefore the one to administer this temple. Now, in contrast, we go to the Supreme Court's judgment in 2020, 9 years later. So, what the Supreme Court does really is only two things. Without getting into much detail, there are only two noteworthy things in our context. One is the Supreme Court sees a seamless continuity in Hindu law from ancient times to today, right? And sees and perpetuates, and it has done it not only in this judgment but in several judgments, a fiction that there is a homogeneous and singular Hindu law which applies to all Hindus across the country. Now, in a 1909 judgment of the Privy Council, in which there was an Indian judge, the first Indian judge to be on the Privy Council. The Privy Council had said that they see these doctrines of Hindu law and institutions created for Hindu law, for the funding of Hindu temples and the administration of Hindu temples, as intended to colonize especially Dravidian areas and bring them under the control of Aryan religion. Not my words, their words. So there was a context in which for over a century, the Indian judiciary during colonial times and after colonial times, and there is almost no difference in their approach. After the enactment of the Constitution, it's as if that event was no more than a statutory enactment. The constitutional significance that the Supreme Court talks about, of understanding that the Constitution is an instrument of social revolution to bring about a completely different social order, is simply not recognized in the interpretation or jurisprudence of the Supreme Court on Hindu law. And they also perpetuate this myth that there is a uniform law, which is basically Brahminical law, that applies to all Hindus across the country. And in a sense, it is part of the construction of Hindu India, to borrow the title from Mukul, Akshay Mukul's book on the construction of Hindu India. So from that perspective, the Supreme Court looks with seamless continuity from the 9th century AD, 18th century, Tripadidanam, and then the other developments almost as statutory developments, but takes no cognition of what was the view of the Constitution of India and the social revolution that it envisages on the relationship between government, people, and religious institutions, particularly the temple, ignoring the fact that the Constitution of India in Article 25 of the Constitution says, and I'll just read it to you, in 25(2)(b), it says, it refers to, it subjects the right to freedom of conscience and the right freely to profess, practice, and propagate religion, to provisions for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So Article 25(2)(b) of the Constitution of India has a very specific provision authorizing reform of Hindu law to address these kind of hierarchical, casteist arrangements, where and because including throwing open temples, Hindu temples, were excluded the public, and so all this is disregarded, and the rights of the autocrat family over this temple are treated, as I said, with seamless continuity. And then because they see Hindu law as one, they declare that the family of the autocrats were what are called Shebayats. Now, Shebayat is a particular type of institution created to facilitate the funding of Hindu temples, where rich people could make endowments to temples. And in return, those people would acquire certain rights in relation to those temples, comparable to, not exactly identical with, the rights of trustees to the temple. So they would donate and they would get a right in return. And the Shebayats, the Shebayat rights are seen as private rights and not public rights, not a relationship comparable to a sovereign or a ruler, and therefore the judiciary has interpreted these kind of private arrangements as above, if you will, Article 25 and above the Constitution, and could not be derogated from by the Constitution or laws. And these are judgments, or this is a jurisprudence with which I personally have huge difference, and I'm not getting into that. But that's the approach they take. So what the Supreme Court did was, whereas the relationship between the last ruler of Travancore and the temple was very much a species of public law, as expressed in covenants entered into at the time of a merger into India, the Travancore-Cochin Act, provisions of the Constitution, including the amendment abolishing the privy purses, and changing the definition of ruler, all these statutory amendments. This Shebayat arrangement is above all that, untouched by all that. Now, the fact that these rulers were the Travancore family, autocrats families, were Shebayats had never been argued in the High Court. It was a new point that was brought up in the Supreme Court. It was not claimed by this family even in the High Court. And the Shabayat, whether Shabayat is applicable to Kerala of the 18th century, I don't believe it is. It was an arrangement in certain parts of India. I don't believe there is a singular Hindu law governing all people who are today called Hindu. And secondly, there is a contradiction between being a Shabayat and the Tripadi Danam, because Tripadi Danam is claimed to be an arrangement where the Maharaja said, I'm Padmanabha Dasa, the slave of the temple, and I surrender everything to Padmanabha. But to be a Shabayat, you don't surrender, you make an endowment of property, but in return, you get certain rights. Now, are they now claiming that Tripadi Danam, unknown to all of us all these years, actually involved a reservation of certain rights, property rights for the family of the rulers of Travancore? And because this was accepted by the family. And so as Shabayats, it was said that the family succeeds the rights of the ruler to control the temple. And on that basis, as I've said somewhere, the throne was put back into the temple by the Supreme Court in 2020. And this, I think, is really an example of Brahminic morality rather than constitutional morality, because the content of the morality or the moral principles underlying this judgment are derived, to be fair, from scriptures and ordinances of Brahminical religion, and in legal codes and rules given by lawgivers, religious practices, and it is done in a detailed and fair way by Justice Lalit. Justice Lalit is a very good judge, and his craft is one of the best in the country. And so the difference between these two judgments of the Supreme Court and the High Court is, we see the Kerala High Court guided by constitutional morality as the Supreme Court demands in 2018, and we see a Supreme Court not guided by constitutional morality but guided by Brahminic morality, and therefore actually reversing the progressive change that came out of the legal actions taken by ordinary devotees. They are people who brought suit were local Brahmin devotees in that area. These were not kind of anti-religious reformers. They were sincere, incredibly devoted disciples of the temple. They brought a suit. They brought about change to protect the temple, protect the public interest. The Kerala High Court, inspired by constitutional morality, protected that. And we had the Supreme Court take a different approach based on Brahminic morality, which, to be fair, also animates a lot of the religious jurisprudence of the Supreme Court for a long time, and set back the social change that the Constitution had envisaged. I'm using this example in some detail, and I'll stop here because I want to make the point that this is not an academic discussion. This is not an academic discussion. It has real life consequences. And I think we have to ask the question, what are the underlying principles? What is the underlying sense of values that drives judgments and courts and government actions and state action? And constitutional morality explicitly gives us the right to question that and hold the state accountable to act within the framework of constitutional values in all their actions, to prevent the kind of regression that we have seen coming from the Supreme Court in this Padmanabha Swami temple case. Sir, Professor Anthony, with your permission, I will stop here and we can have some discussions.
Yes, sir. Thank you, Professor Mohan Gopal, for explaining the importance of constitutional morality and how Dr. Ambedkar tried to include that constitutional morality in the Constitution, and how far the Supreme Court in a particular period strengthened that constitutional morality through its judgment. But at the same time, although while Kerala High Court has in a historic case hold fast to the constitutional morality. We see a kind of Brahminical morality, the arrival of a kind of Brahminical morality through backdoor in the constitutional the Supreme Court judgment in 2020 in the Padmanabha Swami temple. And to see, this is the situation. This is the situation, and see, this is the situation our country reached. So we have, see, as was mentioned by Ambedkar, constitution is paramount of the constitution, and see, we need to cultivate a kind of constitutional culture, and this is in fact the constitutional morality, base of constitutional morality. But at the same time, there are certain problems, and say Professor Mohan Gopal with good examples explained the base as well as the application of constitutional morality in a very good manner.